Norman Williams, New York City defense attorney. Sir, you have been sitting in the seat, and I've been watching you as I've been doing my notes. I believe in rather amazement at what you were listening to with respect to this testimony, because as a prosecutor cross-examining a defendant, you pretty much got everything you possibly could want out of a defendant. What are your thoughts of this cross?
Yeah, no, her cross was amazing. I mean, by nature, prosecutors tend to be horrible at cross-examination because they don't do it a lot. On the other hand, defense attorneys tend to be bad on direct. And I can't for the life of me think of why I would put my client on the stand and expose her to cross-examination when we're talking about the death of a child. I mean,
right. Well, as you know, the defense can only advise a client whether they should take the stand or not, but the client can insist on doing it, and of course, you try to prep them as best as you can. My great friends, Gene Rossi and Judge Ashley, were here, and we were debating the issue of redirect examination. And I think that this cross was so effective and her answers so bad in every category possible: deception and lying to the police, a motive to commit this crime, as well as her saying she basically thinks that she can poke, squeeze, and punch and smack children.
Right.
Okay, it's about as bad you could get, that you may want to get while the getting's good and argue the law in summation. Yet these lawyers are redirecting. What are your thoughts?
After I've destroyed a witness on cross, the greatest gift you can give me is redirect, because I will find more stuff to tear them apart even more. Right.
And you can have more indignation with that kind of thing on redirect examination. Sometimes redirect examination can be more powerful than cross-examinations in the hands of the skilled prosecutor, which we have here. Going back to our point, Norman, I think that when you are doing this kind of case, you want to argue at this point, she didn't mean to do it. She didn't intend to do it. This isn't a murder. It's something less, like endangerment or manslaughter, to try to mitigate the punishment. But if you have that client on that stand for too long lying to them, and that prosecutor is really, really good, and that makes a difference in this equation.
It does.
If you know that prosecutor can pull off a great redirect, man, I would hesitate to be up there right now.
Now, sometimes you have no choice, right? Sometimes you have to redirect, you have to rehabilitate your client, you have to fix the problems in their testimony. But it doesn't always work. And if you can make your arguments notwithstanding what happened on cross, you should just leave it alone. And just make your arguments on the law. I mean, that's just, it's much safer.
As a defense lawyer, right, it's much safer to get up there and try to explain the lies, maybe the deception. Maybe you can get away with explaining why she lied to the police. People lie to the police all the time for different reasons. But that last piece that she gave to the prosecutor, which was that it's okay to hit, punch, and on all those things, poke, which is part of this case, that's really hard to get away from. Why have it come out another 2 times?
Exactly. You just don't want to repeat it. You just don't.
All right, welcome back. That was a part, but a substantive part. It wasn't really as long as I thought the prosecutor, Norm, was going to go in terms of bringing back their case again. It may be that when you stand well, stand still and just move away, because the defense really didn't do anything to rehabilitate her either.
Right.
What are your thoughts?
Yeah, if there's no rehabilitation and nothing new popped up, there's no need to keep banging the drum.
Right.
Like, she's done her job.
Well, you know, this is where the styles of prosecutors and lawyers differ. You know, I guess maybe I was an animal, a homicide prosecutor myself. If you gave me an opening to go back in there and beat her back up again and make the point very directly, I wouldn't do it as large as I did before, but I go right into the focal points of it. That's what I would have done. But you also can't blame the style of when you stand well, stand still either.
Right, because jurors get annoyed sometimes, and you don't want to create sympathy for her.
Good point. So even though she is alleged to have done a dastardly thing and did bad on cross, you certainly don't want the jurors to feel that you're beating up on the defendant. You know, in every, Norman, aspect of this cross-examination, I think the prosecutor maintained a credible tone with her. Sometimes she was difficult and evasive in answering the questions. She brought out so much manipulation and deception to the police, up to and including this whole concept that the little girl squeezed ketchup into the toilet. It's just randomly manufacturing, making things up. And credibility for every witness is very important. It's not just what they say, it has to come from the mouth of a credible person. This prosecutor killed her on both angles.
For sure, for sure. I mean, she's trying as hard as she can to explain herself away, and it just doesn't work. It's just not working. The prosecutor's right there.
And what do you think about demeanor and temperament of the defendant? When you're instructing one of your clients when they're taking the stand, is there any kind of advice that you give them specifically? I do, but I try not to be too instructional with them because I don't want them overthinking things.
Right. You don't want to prepare a person out of their own personality, out of themselves. So you just tell them to look at the jury when they give an answer. Don't argue with the prosecutor when they're questioning. Be respectful. Keep that even tone. Don't lose your temper.
And answer questions directly, because sometimes you can have witnesses that go on and on and on and on, and some that don't give any information at all.
Right, and that's the other problem too, right? That people don't know how to listen to a question and just realize that it's a yes or no answer as opposed to yes, blah, 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 no, blah, blah, blah. And that's where you fall into problems.
Yeah, we used to refer to that as you ask a witness what time it is and they'll tell you how to build a clock.
There you go.
Yeah. So when your witnesses are in a situation like this as a defense attorney, it's interesting because sometimes maybe you need to take an objection and go to sidebar to try to let them recover if they're falling apart like this witness was, but this was just brutal for her. All right, welcome back. My name is Bob Bianchi, fighter for TA in our chat room. Agree with you completely. That poor baby. In fact, Norman, this was going on and the camera was not on us. You were like, poor baby, and you were looking at those cute photos that the Law&Crime Network was showing in juxtaposition to the doctor showing a photograph of, her back of her head from an autopsy. Very tragic, right?
Yeah, it's always sad when a child dies. It really is. And I tell you, this expert, he's probably one of the most qualified experts in the world, but he's boring. And I don't understand why the defense doesn't ask him just more direct questions just to get out the bottom line point first so that the jury can lock onto it. Because I'm sure that their eyes are glazing over. Because you can't hear this guy, the quality of the video is kind of bad, the sound is kind of bad. And jurors have a habit of kind of turning off when experts hit that stand.
Yeah, and I think that there's just something natural about the idea that whenever you put a witness that's coming through a deposition or something, he's not live in the courtroom, takes a lot of zip off the fastball. You want your witness in the courtroom so the jury can feel, listen, touch it, if you will. Norman, you were saying before about witness a little tedious. Forensic pathology can itself, as a subject matter, be tedious.
Yes.
Of course, your presentation to the jury and primacy and recency are paramount so that they're getting it, not falling asleep. So as a defense lawyer, what would have you right out of the gate done with respect to positioning him to be most effective to the jury? I think you said started coming out with his conclusions first. Develop that for me.
Right. I just would have went straight to the autopsy. I mean, if I'm putting on an expert that's going to go against the state's ME, the first thing I want to ask that person is, did you agree with the results of the autopsy? And if they say no, which I'm hoping they will, because that's why I'm putting them on the stand, I'll ask them, explain to the jury why you disagree with the professional that conducted the first analysis of this poor dead child.
Right. So let me just tell you a little bit and see what you think of this. I used to do it sometimes. Every case is a little bit different, where I would do just what you said and get the general conclusions out, and then say, "Okay, doctor, let's back up now." And go to your, so I'm kind of, the reason I was doing that was one, to let the jury know right away, boom, spot on, here's what the results are. And then it gives me an opportunity a second time to reinforce that testimony, sometimes complex testimony, so the jury's hearing it 2 times.
Right, and you also have to be mindful of who your witness is. I mean, this guy's, the sound of his voice and the rhythm of which he speaks is a little soothing. I mean, I'm fighting to stay awake listening to this guy.
And that's a general reaction of our chatters, and that can be the way some of these scientific guys really are. Sometimes, as a lawyer, you can be the animation in that courtroom for those who watch that are young, budding, aspiring lawyers in order to spark this testimony up a little bit. Okay, welcome back. My name is Bob Bianchi. I'll be here till 5 o'clock. Norman, I got one question for you before we take a respite.
Did you say something?
I'm sorry.
Where am I? Good morning.
I mean, look, the chatters are my jury. They're my jury box.
They probably
If
said-
I'm ever trying a case in the future and they're ever putting it on there, I am going to have an assistant there that's like listening to chats, like, hey, this one said don't do this. They're wiped out. I think they're illustrating a point. Is this going on way too long?
Yes, way too long. And it's the end of the day. I got the food coma working because I had a nice lunch.
I know you got that coffee buried under there. I was trying to steal it from you because I was starting to go down. No, it's rough testimony, folks. You got to find a way to make it interesting. I know you just get it on the record, but it's not enough. It's got to be animated, really long.